This is a civil case out of the 6th Circuit, and it demonstrates that even if you're on probation, that does not mean that you waived all of your constitutional rights. And here, this particular person is suing the Sheriff's Department for just that, violating his constitutional rights. Mr. Dawson was on probation. Part of the conditions of his release was the fact that he was prohibited from consuming alcohol, and he was required to submit to random tests for alcohol with a breathalyzer. So on this particular day, the probation officer arrives to his home to try to conduct one of these tests. So he has a breathalyzer in his hand, he comes up to the front door, knocks, but the defendant does not answer the door. He thinks that he can hear the defendant and other people inside the house walking around, so he knocks some more. At some point, he decides to walk around the house and knock on the windows. When nobody still answered, the officer walked to his patrol car, he turned on the siren, he turned all the lights on to try to get the defendant to come out of the house. So then he came back to the house again, he walked around it some more. At the end of the day, he walked around the house around 5 to 10 times. At some point, he walked back to his car again and got one of those yellow caution tapes that the police puts out in the crime scene and put it around the camera that was outside the front door. He was trying to make sure that the defendant could not see him walking around the house. So he knocks out more. Again, the defendant did not answer. Overall, about 90 minutes has passed. 90 minutes later, the defendant finally opens the door and comes out. He says that he was feeling sick and could not hear the door. At this point, the probation officer decides to conduct the breathalyzer, and the defendant actually tests .000, so he did not consume any alcohol. At this point, the probation officer still arrests Mr. Dawson for violating his condition. He did not test for the alcohol when he was required to do so. It was 90 minutes later. Now in this case, we know we don't have a full Fourth Amendment waiver. This means that this particular individual does get the protection of the Fourth Amendment. As you already know, the Fourth Amendment protects you against unreasonable searches and seizures. And in fact, it simply states that the persons will be secure in their home, persons, and effects, and so on. As you can tell, the word home is explicitly in the amendment. So it gets the most protection. The Supreme Court has always stated that you get ultimate protection in your home. The video that I posted before, just last week, in fact, talks about that concept. It tells you that the home is like your castle. So the person always can retreat to their home and be away from any police intrusion inside of the house. Now, I've also posted a video a while back about curtilage. If you remember, that particular video talked about the motorcycle that was parked outside of the house, but really close to it, and it was parked with a cover over it. The police officer came up and lifted the cover. And the question there was that a search of the home or the curtilage? The curtilage is the area that's right outside the house, and it's closely related to the home. It's intimately close to the house. And the Supreme Court has always said that the amendment does not only protect you inside the home, but it also protects you on the areas outside of the home. For example, your enclosed backyard, or maybe your front porch, areas that are really intimately close to the house. So in this particular case, those concepts are in fact related in this case. The officer did come up to the front door, and then he walked around the house 5 to 10 times. So he clearly was at the curtilage of the home. The question is, just because you're on probation, does that mean you violated the probation by not allowing the officer to come into your curtilage? Or did the officer in fact violate your constitutional rights when he entered that curtilage and spent about 90 minutes there? The Supreme Court has carved out an exception for police officers. They have an implied license, or basically permission from the court, to enter the curtilage, to knock and announce on the front door, and if nobody answers, they can even walk around the house and maybe knock on the back door. But if nobody answers, their intrusion has to be brief and quick. If nobody answers, they have to retreat. They have to leave the premises. Just like if they're a regular person or a police officer, it does not matter. Clearly, your invitation is not there to keep staying on the property, so you have to leave. In this case, Officer Dawson violated the defendant's constitutional rights, and he exceeded the scope of his implied license by staying on the premises for 90 minutes, walking back and forth from his car to the curtilage of the home, and not leaving. In those 90 minutes, what he should have done is gotten a warrant to go into the home and actually search the premises. The court holds that the defendant was subject to at least some intrusions by the police that would be warrantless. In this case, the defendant was subject to breath tests that were administered randomly on demand by the probation officer. And the officer did not need a warrant to do that. But that condition did not expose the defendant to warrantless searches of his home or his curtilage. That is a clear violation of his Fourth Amendment rights. If you enjoyed this video, please click like, subscribe, and if you're on probation, remember that you still have certain rights. Read the conditions of release carefully and see exactly what the probation officer can and cannot do, and where your rights have been diminished and where you still have some constitutional rights. And if you think that those conditions are unfair, or if you think that the officer has violated your constitutional rights, call an attorney.